Well, finally, after weeks of testimony, Trump's hush money trial is, well, it's nearing the end of the road. His fate at this hour is in the hands of the jury. President Trump faces 34 felony counts of falsifying business records, which stem from $130,000 in payment that Trump's former lawyer Michael Cohen made to a porn star, Stormy Daniels, none of which is illegal. It's the first time in history a former president has been criminally charged with anything. I think he could be sentenced to prison is shocking beyond belief. The jury could agree on a ruling, by the way, in just a few hours or days or potentially weeks, but probably pretty quick. Joining now to discuss is constitutional law expert Jonathan Emord. Jonathan, some strange instructions from this judge. It just makes it sound like the fix is in again. He said there's 3 different charges here, and he said not only could they agree on one, but they didn't have to agree on all. They could have 4 that agreed on one, 4 that agreed on another, 4 that agreed on another, if I'm understanding this right, and they'd call that a unanimous decision. Even if they don't have a unanimous jury, they're going to call it a unanimous jury. Jonathan, have you ever heard of such a thing?
No, it's outrageous. It very clearly violates the standard of beyond a reasonable doubt, unless you have all of the jurors agree. If there's one juror who doesn't, ordinarily that would be sufficient to acquit. I think this is an example of gross abuse of power by this judge, and I suspect that it's going to readily be overturned on appeal.
So what he's saying is that if 4 out of 12 jurors say yes on one charge and 8 don't, and 4 out of 12 on another charge say yes and 8 don't, and the same thing, 4 out of 12 and 8 don't, they're going to convict him anyway. I mean, honestly. How can this, I know this is a process, this legal thing, this justice system we have is a legal process. But how could this possibly stand up more than a few minutes? I mean, you have to go to an appeals court, but this should be an expedited appeal, should it not?
That's right, because it's so outrageous to not have the standard of beyond a reasonable doubt functioning by allowing less than a complete jury panel to decide your guilt. I mean, this is not criminal law in America.
So how can he, if it's not criminal law in America, which is not, nothing you've ever heard of, how long have you practiced law?
Well, 40 years.
Is that all? So for 4 decades, you've never heard of such a thing. 40 years is all, just 4 decades since I was a kid. Nothing personal, but and here we are. Well, I guess we're breaking new territory here. And this is the problem that Americans have with the justice system today, not just with Donald Trump, but a 2-tiered system of justice in general we see. We see people from the Trump circle get sent to prison for contempt of Congress, while numerous members of the Obama administration and now the Biden administration get hit with contempt of Congress, nothing happens. But if you're in Trump circle, if you're part of that deal, you face a different standard of justice, and I use that term very loosely, Jonathan. Right or wrong?
Well, you're absolutely right. I mean, the entire trial, this case is just a travesty of justice. There's no question about this being an absurd case from the start. The whole case is predicated on a novel theory that can't even withstand scrutiny as to causality. I mean, the fact that let's say that you could demand more than just legal fees on a business document. In the first instance, what is Trump trying to do? He's trying to get funding, he's trying to get support for something, and he's revealing the dollars spent on legal fees. What are the people who receive the document? What do they want to know? They don't want to know the details of the legal services provided. They want to know the cost. So there's no materiality to any falsehood here. There's no intent to deceive. So even if you assume an intent to deceive against the evidence, then how does this tie into an election in any way? First of all the information related to Stormy Daniels was already in the public. So the idea that this would somehow affect judgment or votes is beyond the rationality. It fails even just a basic logic test. And yet they have no evidence that anyone's vote was influenced in any way. They don't even present that evidence. So the whole thing is a ridiculous, really clearly biased political trial. We had hoped we would never see this in America, and now we're witnessing it writ large. This is the grossest abuse of justice, really, in our history, with rare exception. I just don't see how it's possible that this can withstand appeal.
And I want to ask you that. On that point, Jonathan, with your 40 years of experience, if this were your case, if this were your client, your defendant, if you will, what would you do to proceed next? I mean, because I'm saying an expedited review of this case is warranted for a variety of reasons. Not just the 3 calls for mistrial or the fact that the prosecution got to run wild yesterday and say also they basically testified in the case. The fact that Stormy Daniels and whatever she did or did not do with the former president is irrelevant to the case. The fact that Michael Cohen, a convicted serial perjurer, is your star witness, and he's held up to some shining standard for which he can't achieve because he lied during the testimony in this case, we've been led to believe. Can you ask for an expedited appeal? Can that happen? Can it be done?
Of course. And what you would ordinarily do is seek a stay of the judge's determination related to the verdict. And you would, seek first a judgment notwithstanding the verdict, but that would be denied. Then you'd seek a stay of the order. That would be denied. Then you go to the Court of Appeals and seek a stay of the lower court's determination. And then you would probably get it pending judicial review of your appeal. Because of the novel circumstances in this case, because of the novel arguments raised, you would ordinarily get a stay, and he would not go to prison. Now, they might temporarily, if he's convicted, put him in the hoosgow, but he would immediately be subject to release because of the absence of any sound foundation for this determination, or even the whole case. I mean, the whole case is a joke.
And here's the thing. I have friends of mine that are attorneys that are left of center, a number of them. Not one of them thinks this is a legitimate case. In fact, they are all appalled. They're not far left fringe people, though. They're more traditional liberal Democrats, if you will. They are appalled that this is happening. They agree with you. This should never happen in America. This case should never even exist. And it makes you wonder if Donald Trump can be convicted on this outrageous case that's manufactured from misdemeanors that have long since passed the statute of limitations that weren't crimes to begin with, even if you could have gotten them in time, to somehow turn that into a felony. Oh, and then federal charges today, we learned, because it's an election interference, which is federal, not even state purview, is it?
Not even, look, the whole argument is ridiculous. First of all, the FEC looked at this very matter and determined that there was no foundation to proceed because no campaign funds were expended, right? So there's no issue as to federal election law at all because there were no campaign funds expended in association with this. As a consequence, the whole idea that you would somehow proceed on a state level and evaluate federal law in the first instance that has already been evaluated and determined not to apply, and then somehow say some new organic judgment out of Alvin Bragg that's never been heard before that there is an election law violation when there's no campaign fund expended. I mean, if you have look, Bill Clinton did this in spades with his catch and kill sort of program where he would find all those women that he had affairs with and he would pay them hush money. And he expended his own personal resources for that. They could have gone after him multiple times under this theory, but of course they never would.
I'm sorry, for example, did Paula Jones not get $850,000? $850,000 25 years ago. Adjusted for inflation, that's well over $1 million today. We're quibbling over a $130,000 non-disclosure agreement, which today in America, thousands of other non-disclosure agreements that are perfectly legal will be signed and executed as contract law in America, won't they?
That's right. This is really a situation where not only have they manufactured the grounds, but the grounds themselves are preposterous. In other words, they don't even connect. The dots don't connect. There has to be causality. They have to prove intent. They have to prove that Donald Trump intended not only to mislead people as to what those legal services were when he had legal services, allowed his lawyers to put legal services on there, which is true.
Give me the best case here, Jonathan. Give me the best case scenario to get to the Court of Appeals. And let's say, because you said it'll fail the first round, then it'll get to the Court of Appeals. Can it get there by August or September? How quickly can it get there?
Well, it could be handled, I mean, within a matter of days, actually. The court could stay the judgment of the court below pending review, and then it may take months in order for them to complete the review. On an expedited basis, perhaps they could do it in a month. It all depends upon the panel that is to review the case, but ordinarily it could be done very quickly. This is a case that is novel and that threatens an election, so there ought to be urgency to it. It's interfering with the conduct of an election. Talk about election interference. This case is plainly election interference. Let
me ask you this, because here's something else that I hear, and it's an important question for the layman, which is me. Could a case like this be... could you sidestep that process? Could you appeal directly to the United States Supreme Court because of what you just said? Because it is involving an election, the leading candidate, it's clearly far afield from any legal standard and all of these novel ideas like how the hell can we get Trump? That's what it looks like. Can it be appealed in a more direct way to the United States Supreme Court and avoid all the intermediary stops, or is that the process you have to go through? I'll give you the last word.
Well, I think they do have to go through the state process because, remember, under the Constitution, the states control the conduct of elections. And while they're invoking federal election law here, that's not the primary basis for the conviction. It is whether or not, in the first instance, he committed these fabricated, made-up felonies under state law. So the court would probably not take a case until such time as the state had completed its review of the process.
In best case scenario, could the appeal, do you have faith in the appeals court of New York?
Well, no, but I have to say that I have more faith in spades than I do in Judge Marchand and in this jury. I do think, however, that there is a reasonable likelihood of acquittal.
There is what likelihood?
There is a reasonable likelihood of acquittal even under these bogus instructions from the judge. There's a chance that the jury just will not convict him because the evidence is so flimsy. Two lawyers in that jury.
I'll give you that. We'll find out if they're honest lawyers, won't we? Because we'll know their names as soon as they come out of that jury room. We will know, and these guys and their reputation will be on the line as well. Sir, I could sit here and continue to fillet this case for sport, but we'll leave it there for now. Jonathan Emord, thank you for being here.
You bet. Thank you.